D, update on reasonable accommodations policy. Ms. Pova,
Kathleen,
would you?
could you address the board about this request?
Certainly. So I'm sure you're all familiar with our reasonable accommodation policy as it stands. Hasn't changed much in the last year or so since we updated it. The only thing that we are suggesting, actually, with the advice of our legal team, is to make a small amendment. There's no material change to the policy. The only language that we want to add is around, and again, anybody can request a reasonable accommodation. They can request it at the time of application. We notify all of our applicants, all of our tenants that are in housing, and anyone who's violated the lease or is even on eviction. We are always doing our due diligence and notifying residents and applicants of their right to request a reasonable accommodation. This is not changing their right to request it in any circumstance. This has more to do with when we process a reasonable accommodation that is put on our desk after we've already started court proceedings with that tenant. So this was only in the cases of a tenant who is already who's already been served, who's already filed summary process on, and in the proceedings puts in a request for a reasonable accommodation at that time. We still are required to process the request and make a decision as to whether approve or deny, based on the same criteria that we always use when we process those requests. But if in the case of a denied request for reasonable accommodation that does emerge in the legal process, we are not going to be, the amendment is that the right to grieve, or the entitlement, I should say, the privilege that they can go and grieve that decision to our grievance panel would be, that right would be waived. And only in that case. In every other situation where a reasonable accommodation request is placed and they get denied, they have the path of going through that due process and having it reviewed and they can appeal basically the decision. But what we believe, and I believe Attorney Maloney would agree with me, that in a situation where we already have, for example, an execution for possession on a unit, and the judge has already made that decision, and then at that point we get the reasonable accommodation request, everything has to stop. We have to process that request. And we can approve it, we can deny it based, again, on that criteria, but the bottom line is, if in fact that there is no nexus between the request for accommodation and the actual disability-related need, and the request gets denied, to go in that internal review process is just going to delay our legal action, which we've already gotten the ball rolling on. And they're already receiving their due process rights in the court of law. So we're just basically making that one change to the policy. It's really not a material change. It's more around the appeal process after a denial has been made under certain conditions.
Kathleen, could you explain to the board whether other housing authorities have successfully adopted this?
Actually, I got this idea from the Boston Housing Authority. This is this exact language is in their reasonable accommodation policy as well. And I know they have a very strong team of attorneys, so I highly doubt that they would put something in a policy that wasn't legitimate. So. And I don't believe every housing authority even goes through the grievance panel or grievance process when reasonable accommodations are denied. We afford our applicants and tenants that right, but it's not a requirement. It's just a best
Thank you.
practice.
Does any commissioner have any questions for Ms. Pova? If not, there a motion to approve?
So moved.
Motion made?
Second.
Second? All in favor?
Aye.
Aye. Opposed, none.